Yes. So the whole syllabus of the evidence law that we will discuss throughout this semester has been divided into 6 chapters, or you can say 6 units or 6 chapters. And each chapters then subdivided into some parts according to the convenience. The first chapter, and the name of the first chapter is General Issues Relating to Law of Evidence. And this chapter we have to complete in the 6th period, that means in the 6 classes. It has 4 parts. The various issues that related to the evidence law, like, what is fact in issue, what do you mean by oral evidence, documentary evidence, then what is adversarial system, inquisitorial system, how the evidences in these two systems are different. Then what do you mean by proved, not proved, disproved, these type of the things. So this first chapter, as such, in this first chapter, there is no case assigned in our case material. And this first chapter is divided into the 4 parts according to our convenience. The first part is related to that what is the purpose of the evidence law. Just think it. Suppose there is a crime like the murder or the rape, anything you can take for example. So the murder has been committed, the rape has been committed, and according to the Indian Penal Code, there is the punishment that has to be provided to the accused. But how to prove that this particular offense has been committed and how it has been committed? What was the reason? What was the purpose of the accused? So this is basically reenactment of the past event for deducing the blameworthiness or entitlement of the parties is the core inquiry of evidence law. That means the basic purpose of the evidence law is to creating that story by which in the criminal case the offense has been committed, or in the civil case the entitlement, whether it is the issue like the issue of the contract law. So how contract has been breached by party A, so whether party A is liable or not liable. So evidence law play that role. Now, to movies you can watch to understand more about the evidence law. Recently I have watched, that's why I'm recommending. On the Hotstar, there is Criminal Justice 1 and the Criminal Justice Behind the Closed Doors, that means the second one. These are the web series. And in these movies, the first Criminal Justice, one murder has been committed. So how the police officer do the investigation, that basically the reenactment of the past event, that in this way the accused has come, this was the purpose, then the accused has stabbed the victim, all these things. And this is not only the things done by the evidence under evidence law, even the media person, they also tell a story that how all these things had been happened. Sometimes the authors, historian, how the Tamur came to the India, or the death of the Babur, etc. And lawyer also. So they all do this reenactment of the past event. And there is a similarity. The similarity is that there is 2 types of the things are used, or 2 evidences are used. One is the direct evidences. Suppose there is the murder committed by A and person B is the eyewitness who watched the murder, the, the offense of the murder. So this is the direct evidence. Sometimes direct evidence is not possible because accused is not doing the offense always to, in open day, or you can say, uh, before the people. So in that, the circumstantial evidences, like the last scene theory, एक पर्सन ए है एंड उसके साथ एक लड़की घूम रही है, उसके 6-7 घंटे बाद में पता चला कि लड़की किडनैप हो गई, लड़की वापस नहीं आई। तो जिस लड़के के साथ वो घूम रही थी उससे होगा कि भाई आपको साथ लास्ट सीन देखा गया, एंड ऑल दिस प्रिंसिपल यू विल फाइंड इन द एविडेंस एक्ट। सो दैट इज लास्ट सीन थ्योरी। अब एक्चुअली क्या हुआ, दैट इज द डिफरेंट थिंग, बट ऑल दीज थिंग्स इज थ्रू द circumstantial evidences is also the reenactment of the past event. Now, these are something. I'm not going deeper into the Evidence Act or the provision. We are just understanding that how the evidence law play its role. Okay. Now, the second thing that we will discuss under the first part is that the rule of the evidence law is different with respect to the adversarial system and inquisitorial system of the justice. As some of you may be aware that there are two types of the criminal justice system. One is adversarial and another is inquisitorial. Adversarial, like the India, Britain, Pakistan, we follow adversarial. A and B, both the parties are adversary and judge is neutral. This system is known as adversarial system. The second type of the system is inquisitorial system. Inquisitorial, in which judiciary play the proactive role. Inquisitorial, inquisition, बच्चे की होती है ना जिज्ञासा, यहाँ पे जज को कोई मतलब नहीं। सपोज there is allegation against A that A has committed the murder of B. But A is able to prove that at the time of murder, he was not in India, he was in USA. उसने प्रूव कर दिया जब मर्डर हुआ तब मैं इस देश में नहीं था, मैं अमेरिका में था। Maybe through the ticket, passport, stamp and all other evidences. Through these facts he has proved. Now A will not be convicted. And अब ये नहीं कहा जाएगा कि भाई आपने नहीं मारा तो किसने मारा। That's the another thing. That is the subject of another inquiry. But the case will rest on this point if further things has not been, come before the court. So this is, the way in which our adversarial system work. Inquisitorial system, because we are not studying the inquisitorial system in the detail, so every minute detail we don't know. But in the inquisitorial system, like in the France, etc., the judiciary play the active role to find out the truth, because the very purpose of the evidence law is to find out the truth, to reenacting the past event, so to find out that how possibly the crime had been committed. Okay. Now, this is the first part that we will discuss under the chapter first. The second part is about our statute that we will discuss. तो बेर एक्ट जो हम पढ़ते हैं या जो लॉ जो हम पढ़ते हैं, जैसे हमारा जो एविडेंस एक्ट है, that has been enacted in 1872, Indian Evidence Act 1872. Now the question is that before 1872 which law was prevailing? ऐसा तो नहीं उससे पहले ट्रायल नहीं होती थी, क्राइम नहीं होता था या सजाएं नहीं होती थी। So the history of the statutory evidence law in India, and the two aspects we will discuss. First is the pre-enactment, that before 1872 what was the rule of the evidence law prevailing in India, and after the 1872. It is not that once a statute has been created, it will not be amended. ऐसा नहीं है कि कोई भी कानून बना दें तो वो चेंज नहीं होता. Even our constitution that has been enacted in 1950, it has been amended many times, and it is not same as the original constitution. अगर आप स्टेट की भी बात करो तो पहले ओरिजिनल कॉन्स्टिट्यूशन में 4 तरह के स्टेट होते थे, पार्ट ए, पार्ट बी, पार्ट सी, पार्ट टी. अब 2 तरह के होते हैं, स्टेट एंड यूनियन टेरिटरी. सो अमेंडमेंट होते हैं, अमेंडमेंट के साथ लॉ चेंज होता है. लॉ इज एन इवॉल्विंग सब्जेक्ट, और इतना इवॉल्विंग और वोलेटाइल है कि हो सकता है कि जो चीज आज पढ़ रहे हो सेमेस्टर के एंड तक भी ना हो. द कंपनी लॉ, when I was LLB student, we used to study company law 1956, and when I was in LLM, the company law 1956 was not in force because it was repealed, and the new law, company law 2013, has been enacted. So the pre-enactment, you understand, the past enactment means any development, any changes through the amendment by the parliament or through the judicial orders. जुडिशरी भी किसी का इंटरप्रिटेशन देती है तो उसके हिसाब से लॉ चेंज होता है. The law cannot be changed through the amendment only. The most wonderful example is Article 21 of the Constitution. Article 21 of the Constitution, the one-line article, has never been amended in the history of the constitutional law. But the interpretation, the understanding of Article 21 has been changed so far, so vast. Before 1978, Maneka Gandhi versus Union of India, AIR 1978 Supreme Court judgment, the understanding of Article 21 was that the right to life means right to only the physical existence. And after this judgment, the new horizon has been given, provided by the Supreme Court through its judgment, that right to life means anything and everything that makes life a meaningful, a dignified, is included in Article 21. And now the situation is, some jurists say that Article 21 is, under Article 21, there are many rights: right to clean environment, right to healthy air, right to noise-free environment, right to medical health, so many things, that Article 21 is an unwritten constitution. So here, under the the second part of the chapter 2, we will discuss the history of the statutory evidence law, the pre-enactment development and the post-enactment development through the judiciary, particularly the appellate court, high court, and the Supreme Court. Because the judgment of the High Court and the Supreme Court are binding, that you might have read during your jurisprudence classes. Okay. The third portion, under the third portion, 8 important things we will discuss. 5 plus 3, 8. What are those important terminologies? The concept like facts. What is facts? Okay. In a inquiry, in the trial of murder, the question is whether, suppose there is a trial of murder, allegation is against A that A committed murder of B. So the fact in issue, the larger fact in issue, whether A committed murder of B or not. If you break down it, you have read the criminal law, IPC, and the various ingredients of the murder, the death, and the death with the intention. So actus reus and mens rea. Both these things has to be the thing. Okay, actus reus means death of the person, and death has been caused by this person A. डेथ डेथ से काम नहीं चलेगा. The death of the person B caused by A is the fact in issue. ये ऐसा फैक्ट है जिसके ऊपर इशू है. ए कह रहा है मैंने नहीं मारा, बी कह रहा है तुमने मारा है, बी की साइड से. And the second is that it has been committed or the death has been caused with intention to cause death, as according to 300. Definitely the inquiry go from 290 to 300. Okay. The second is facts. For proving these things, various facts can be adduced. अब उन्होंने ए को मारा, उन्होंने कहा भाई जो चाकू इनके हाथ में था उसकी फोरेंसिक रिपोर्ट आई है, चाकू इसकी शर्ट पे जो ब्लड के स्टेन थे उनकी फोरेंसिक रिपोर्ट. दीज आर द फैक्ट्स एंड दीज फैक्ट्स आर प्रूव्ड विद वेरियस एविडेंसेस. अब एविडेंस दो तरह के होते हैं, या तो किसी ने ओरली आके बोला हो या किसी ने कोई कागज दिया हो. सो द एविडेंस कैन बी ओरल और डॉक्यूमेंट्री. Evidence can be oral or documentary. Then the information technology has been evolved. Now the document are neither oral nor the evidence. Documentary, it form like our class, it has been recorded. So this is electronic evidence, digital evidence. Earlier it has to be oral evidence as documentary evidence. Then the relevant fact. Relevant fact means you have to prove all these things through the relevant fact only. आपको कई बार मूवीज में, काफी मूवीज में गलत भी दिखाते हैं, बट इन सम गुड मूवीज when one side want to adduce a fact, the other side object, no, this is not relevant. The case has to be proved through the relevant fact only. If there is the inquiry, if there is the trial of murder against A, the fact कीजिए उन्होंने पहले भी किसी को मारा था, इसका करेक्टर ऐसा है, ये these are not relevant facts. So these facts even cannot be allowed to give before the court. So only relevant facts are used. Two things you can write. Section 136. This is your homework also. You can read through the bare act of the Indian Evidence Act 1872. Section 136, that the things has to be proved by the relevant fact. अब relevant fact क्या है? Section 5 says that relevant fact are those that are mentioned from section 6 to 55. मोटा मोटा ये लगा लो, सेक्शन 5 से और 55 में जो जो चीजें रिलेवेंट बताई हैं, all those facts you can adduce, उससे ज्यादा नहीं. The second concept is admissible. Even all relevant facts are not admissible. So the admissibility and relevancy are two things. Okay. For example, बड़ा इंटरेस्टिंग एग्जाम्पल है. सपोज ए के अगेंस्ट एलिगेशन है that A has committed murder of B. During the trials, पुलिस has produced, सर इन्होंने तो कन्फेशन किया हमारे सामने. अब जब जिसने मर्डर किया है वो सारा बता रहा है कि मैंने किया, वहां से चक्कू लाया, फिर ऐसे मारा. He did the confession. वो सारा इनेक्टमेंट बता रहा है कि हाउ ही डिड. बट इट इज रिलेवेंट. इससे ज्यादा रिलेवेंट और क्या चीज हो सकती है? बट इज इट एडमिसिबल? आपको शायद नहीं पता, बट इसका कंसीक्वेंस सोचो. अगर इस तरह की पावर हमने दे दी तो पुलिस तो किसी को ढूंढेगी नहीं, एक ही को पीट पीट के कन्फेशन करवा लेगी. एंड दैट्स व्हाई अंडर सेक्शन 25, ये अगला सेक्शन आप लिख सकते हो, ऑफ द Indian Evidence Act 1872, the confession before the police officer is not admissible. On this, there is the famous case, Agnu Nagesya versus State of Bihar. इसमें अक्यूज ने सारा मामा चाची सबको काट दिया एंड देन ही वेंट टू द पुलिस स्टेशन, रॉयल स्टाइल में भाई साहब बैठे और सब कुछ बता दिया कि मैंने कैसे कैसे आई कमिटेड द क्राइम, बट बिफोर द कोर्ट दिस इज covered under section 25, the confession has no value. Okay, because there is the cardinal principle of the criminal justice. And what is that cardinal principle? That maybe the 100 accused may go free, but one innocent cannot be punished. Okay, so that then the proved, disproved, and not proved. So these 8 things we will discuss: the concept, facts, fact in issue, relevant fact, evidence, oral and documentary, proved, disproved, and not proved. And the 4th one is, like, there are 2 major streams of the law. Even you have heard these, even if you are villagers, दीवानी और फौजदारी. दीवानी मतलब रेवेन्यू वाले मैटर, सिविल मैटर. फौजदारी मतलब लड़ाई झगड़े वाले, सिविल एंड क्रिमिनल केसेस. Civil law and criminal law. Similarly, there are 2 major branches of law. One is substantive law and another is procedural law. Now, what is substantive law? Can anyone tell me what is substantive law? Yes, guys? Please. Yes? Anyone can try what is substantive law? Mahesh? Yeah, IPC. That is example. IPC, perfect. Very good. Brilliant. But कहते किसे हैं? मतलब पूछे कि किस चीज को कहेंगे?
The laws, those define offenses.
Those define of?
Offenses.
Not strictly, but yeah, good attempt. Good attempt. Arshad, good attempt. So, I'm telling you, substantive law, yeah, some Ajay Kumar Gon, substantive law, good. Substantive law means, basically law में हम पढ़ते क्या हैं? Like in the mathematics, we do calculation. Calculation करते हैं mathematics में. कभी परसेंटेज निकाल रहे हैं, कभी वर्क आवर निकाल रहे हैं, कभी ऐड कर रहे हैं, कभी सब्सट्रैक्ट कर रहे हैं. बट अगर मोटा पूछे तो क्या कहेंगे? That in the mathematics we study calculation, and in the law we study rights and liabilities, अधिकार और जिम्मेदारी or duties, you can say. So the substantive law is that branch of law in which rights and duties are prescribed. Like IPC का आपने एग्जांपल दिया, सिंपल ले लो, मर्डर ले लो, section 300. So, and read with 302. Right is that every person has the right that he should not be killed, and the corresponding liability on the every other person not to kill. Okay, and for that there is the punishment also. So rights and liabilities. Yes, Suryakant? Yeah. So similarly, in the Indian Contract Act, there is the rights and liability. Any things that you can take in which there is the rights and liability, that is substantive law. So the IPC, the Hindu Marriage Act, Hindu Succession Act, property, this Property Act, then Constitution, then this IPR, Trademark, Design Act, then Competition Law, all these things are the substantive in nature. The other branch is the procedural. अब substantive है that if the offense of hurt has to be is committed, then this is the punishment. लेकिन आपको पता नहीं कहाँ पुलिस में जाना है, कैसे प्रूव करना, कोई प्रोसीजर पता ही नहीं, कैसे करोगे? So the branch of law that prescribe the procedure to realize the substantive provision is known as procedural law. And as I earlier said that there are two branch of law, one is the criminal, another is the civil. So दोनों के लिए procedure भी अलग होगा. So for civil matter के लिए हमारे पास है Civil Procedure Code 1908. Civil Procedure Code 1908, CPC 1908. And for the criminal procedure, we have the new act, the Criminal Procedure Code 1973, small CRPC 1973. Now the question is कि ये जो हमारे हाथ में ये जो बेर एक्ट है, इंडियन एविडेंस एक्ट का, फिर ये क्या है? What is this? Is it civil or criminal? Yes, guys? हमने अभी पढ़ा, समझा कि सिविल लॉ, क्रिमिनल लॉ, प्रोसीजरल लॉ एंड substantive law. Now the question is, deliberately I had not told you that Indian Evidence Act civil category में no, इसमें procedural category में fall करेगा substantive law में. This is your task. Is Indian Evidence Act is procedural law or substantive law? Yes, guys? दो ही ऑप्शन है, कुछ तो बता दो. 100% पॉसिबिलिटी, 50% पॉसिबिलिटी है सही होने की. या तो सिविल, या तो प्रोसीजरल होगा, या सब्सटेंटिव होगा. सृष्टि श्री, यस प्लीज आंसर दिस क्वेश्चन.
Yes, sir.
Is this Indian Evidence Act is procedural law or substantive law?
Sir, I think neither.
इधर अच्छा, आपने तो एक नया ऑप्शन खोल दिया. नो, it is procedural law because it prescribes the procedure how to prove the things. Substantive law is that branch of law that prescribe rights or duties, and the procedural law is the procedure to realize the substantive provision. So how to prove, that is prescribed by the Indian Evidence Act, and so it is a procedural law also and civil law also. It's not कि criminal law के लिए अलग evidence act है और civil law के लिए अलग evidence act है. And that's why the the provisions, the sections of the Indian Evidence Act, you will find both the terminology as related to civil law and criminal law. Some provisions are exclusively related to civil law, some provisions are exclusively related to criminal law. Like section 25 confession. Confession तो civil law में तो होता ही नहीं. It is applicable to criminal law. But the Indian Evidence Act is applicable to civil law also and criminal law also, and it is procedural law. Okay. So these four things we will discuss under the chapter first. Any question from this portion or any query that you want to ask? Yes, Mr. Asaf? Ajay?
No, sir.
No. Okay. Second chapter. The second chapter is most important and most exhaustive. सबसे बड़ा और सबसे इंपॉर्टेंट चैप्टर रिलीवेंसी एंड एडमिसिबिलिटी। इससे पहले हमने बात की ना कि रिलीवेंसी, ओनली रिलीवेंट फैक्ट ही कोर्ट के सामने एड्यूस किए जाएंगे, एंड रिलीवेंट फैक्ट में भी जो एडमिसिबल होंगे, सारे रिलीवेंट फैक्ट भी नहीं होंगे, लेकिन एडमिसिबिलिटी केवल रिलीवेंट फैक्ट की होगी। दैट मीन द रिलीवेंट फैक्ट इज द लार्जर सर्कल एंड एडमिसिबिलिटी इज द स्मॉलर सर्कल। ओके, सो various sections we will discuss, and this has to be completed in 14 periods. That means in half month we have to complete it, and it is divided into three parts according. The first one is from section you can say 5 to 11. So this first part is divided into two further subpart. One is logically relevant facts, section 5, section 6, section 7, section 8, section 9, section 11. Section 11, plea of alibi. You can write it. If there is the allegation against A that you have committed, and he is able to prove that he was not at that place, plea of alibi, that is also relevant fact. Res gestae, the whole transaction. These phrase you can write res, RESGESTAE, the whole transaction. चोर आगे है, पीछे उसके पुलिस वाला है, फिर और आगे गए, फिर किसी ने गोली की आवाज सुनाई दी, फिर उसके बाद में हॉस्पिटल में लिए, चोर बता रहा है कि पुलिस वाले ने गोली मार दी. So all these transactions that make a full chain is known as res gestae, relevant under section 6. Previous conduct, subsequent conduct, all these things are relevant, section 7, 8, 9. So these things we will discuss. And under this first part, second subpart is the provision related to conspiracy, section 10. So पहले हिस्से में हम पढ़ेंगे 5, 6, 7, 8, 9 and 11. And second portion, the special class of relevant fact related to conspiracy. All these things you will find in your case material. See, to understand Indian evidence law, three things you require. तीन किताबें होनी चाहिए आपके पास. First is this Baer Act. ऐसा एक Baer Act खरीद लो पतला सा, or you can download it also. The Indian Evidence Act 1872. The second thing is our case material. Case material also you can download it from the website. And the third one is one book. And which book you can should purchase? Two books are prescribed according to your level and understanding. One is Vipa P. Sarthi and another is Justice Munir book. Justice M. Munir, Justice Muhammad Munir, he was the second Chief Justice of the Pakistan High Court. Because, when the Indian Evidence Act was enacted at that time, there was no Indian, India was there, there was no Pakistan. So he was born in Punjab, and later on, he moved to the Pakistan. And this book he has written, that Justice Munir book, you can purchase. And another book, Vipa P. Sarthi, that book also you can purchase. इन दोनों में से कोई एक किताब ले लो. These three things you must have. So what the syllabus I discussing, you can find it in your case material. Okay, but the discussion is to understand clearly that under which chapter how much time we have to assign, what various things we will discuss, and all other relevant things, so that the students feel acquainted with the subject. Otherwise, if I go directly into the Indian evidence law, so पहले दिन आपको लगेगा कि ये क्या चीजें हो रही है. So just to understand, so many things you have understand what is evidence, the oral evidence, documentary evidence, and this electronic evidence. Then the things that you have, that what is relevant fact, relevancy, admissibility, criminal law, procedural law, civil law, all these things you learn from this. Okay, so the from the second chapter, the first portion is about, from section 5 to section 11. Okay, it is divided in two subparts. One is, the logically relevant fact 5, 6, 7, 8, 9, and 11. And the second is special class of relevant fact related to conspiracy, section 10. The cases like, RM Malkani, etc., that provided in your case material. Various cases has been provided in this 17 cases. So these cases related to various aspect or the various sections of the chapter 2. The second portion of the chapter 2 is stated relevant fact. Stated relevant fact means that already has been stated. कहीं पे पहले ही कहे गए हैं, उनको कैसे प्रूव कर सकते हैं. Now this second portion of the chapter 2 is further divided into three subpart. One is the admission. Admission मतलब आपने admit कर लिया. जैसे मैंने कहा कि कॉन्ट्रैक्ट जो था, suppose there is the question between A and B related to a contract. A is contended that there was a contract between me and B. B is saying that there was no contract. But कभी पहले किसी C के सामने B ने कहा था कि भाई हमारे बीच में कॉन्ट्रैक्ट हुआ. So this C can, give the evidence that before me B have admitted this fact. So this is admission. Section 17 to 23 related to admissions. 17 से 23 एडमिशन. फिर आता है कन्फेशन. ऐसा एडमिशन जो इस तरह से एडमिट कर ले कि सारे ऑफेंस को ही एक्सेप्ट कर ले, दैट इज कन्फेशन. I'm just giving the loose, meaning. More strictly, when we will discuss the direct, we will discuss that what is the whole domain of the confession. So the confession from section 24 to 30, section 24, 25, 26, 27, 28, वो सारी चीजें. अगर किसी को दारू पिला के कन्फेशन लेते हैं या किसी को स्ट्रेस में लेके कन्फेशन लेते हैं. एक मूवी होती है ना जिसमें हेमा मालिनी होती है, कुछ इंटॉक्सिकेटिंग सब्सटेंस पिला के कन्फेशन लेती हैं. या 2 आदमी है, 3 आदमी है, उसमें से एक कन्फेशन देता है कि नहीं हम दोनों ने मिलके उसका मर्डर किया. सो whether this confession will be applicable against B also. उन्होंने अपने खिलाफ तो दिया ही दिया, B के खिलाफ भी दिया. So all the provision related to confession are from section 24 to 30 of the Indian Evidence Act. And believe me, this is your first class और आज से लेके आपका last day, जब तक आप इस legal profession में होंगे, ये चीजें आपको याद रखनी है और याद रखनी पड़ेंगी. These are so important things. Then the third one is dying declaration. A stab B. हॉस्पिटल में B ने कहा कि नहीं मुझे A ने मार दिया, and then he died. So this is already stated fact. अब इस फैक्ट को जिसने रिकॉर्ड किया, पुलिस वाले ने या डॉक्टर ने, इस फैक्ट को हम, ये रिलेवेंट है या एडमिसिबल है नहीं है, that is dying declaration. Dying declaration means the person who says something before dying, whether he has the idea that he will die or will not die, but when he died, that statement. जनरली आपने कहा कुछ भी चीज, उसके बाद में आप मर गए, दैट इज डाइंग डिक्लेरेशन. चाहे आपको अंदाजा हो कि मैं मरने वाला हूं या नहीं, हाँ आपने स्टेटमेंट दी, बट सब्सिक्वेंटली यू डिड नॉट डाई, सो दैट वुड नॉट बी डाइंग डिक्लेरेशन. अब इसके पीछे सारा पर्पज है. व्हेन वी विल डिस्कस इन द डिटेल, बिकॉज 3 तरह से होता है, एग्जामिनेशन, क्रॉस एग्जामिनेशन एंड री एग्जामिनेशन. जो आदमी मर ही गया उसको आप क्रॉस एग्जामिन नहीं कर सकते ना. So that was dying declaration. And there is another theory is also related how dying declaration is admissible and important. Okay, important thing तो हो ही गई, लेकिन जब हमने statute के according वो कर दिया that all those things that are important are admissible as according to our Indian Evidence Act. So now we use term only the relevant, not the important. Okay, and the third person is the opinion of third person when relevant. In the trial चल रही है, फायर किया, ये गोली उसी से नहीं है, वो आके एक्सपर्ट बताता है। उसी का अंगूठा है कि नहीं, वो फिंगर एक्सपर्ट बताता है। अब यहाँ पे तीसरा आदमी बता रहा, वो कह रहा भाई साहब तुमने थोड़ी देखा है। सो ही इज द थर्ड पर्सन बट ही इज गिविंग द ओरल एविडेंस कि नहीं ये ए का ही अंगूठा है। और राइटिंग वाला हैंड राइटिंग में भी एविडेंस देते हैं कि नहीं ये इसकी राइटिंग है। So all the opinion of the third person, that is known as expert opinion. So how that is relevant? There are provision, section 45 to 51. Judgment भी, पुराना judgment भी relevant हो सकता है। Character का भी होता है, but that is not prescribed here. How the character is relevant? Section 54, 5, etc. Okay. So this is about the chapter second. So the chapter second is relevancy and admissibility of the facts. It is divided into 3 parts. The first part has 2 subparts: logically relevant fact, section 5 to 11, special class of relevant fact related to conspiracy, section 10. The second part is stated relevant fact that already has been stated. Admission, section 17 to 23, confession 24 to 30, dying declaration, section 32, clause 1. Third part, opinion of third person, section 45 to 51. Okay. Anyone who want anything who want to ask, or otherwise I will move to the third chapter. Yes guys, कुछ पूछना है आपको इसमें से, सेकंड चैप्टर से रिलेटेड कोई भी चीज आपको? सो रहे हो सारे लोग? सूर्यकांत, मिस्टर सूर्यकांत।
यस सर।
सेकंड चैप्टर से कुछ आपको पूछना है या कुछ कोई भी किसी तरह के क्वेरी या किसी तरह का कोई आप? नो, ओके, थैंक यू। नाउ कम टू द थर्ड चैप्टर. The third chapter is on proof, and we will discuss this third chapter in 7 periods because it is prescribed according to our syllabus. एक दो ऊपर नीचे हो जाता है, that's not an issue. This third chapter is divided into 2 parts, part A, part B. Part A में हम करेंगे 3 चीजें डिस्कस, 3 things. First, whenever there is a trial, whenever there is the civil proceeding, आपको चीजें प्रूव करनी पड़ती हैं कोर्ट के सामने. In the part A, the first thing is that the facts which need not to be proved. कुछ ऐसे भी फैक्ट हैं जो आपको प्रूव नहीं करने हैं कि जी उस दिन संडे था, संडे को छुट्टी थी इसलिए मैं ऑफिस नहीं गया. अब संडे को छुट्टी थी, दैट यू हैव नीड नॉट टू बी प्रूव्ड. So this is just an example. So there are many things which you need not to be proved. Maybe that is in the public domain and all other regions. In the detail we will discuss when we will discuss chapter 3. So in the part first, the first thing is facts which need not to be proved, section 56 to 58. The second thing is the facts which the parties are prohibiting from proving. अभी तो प्रूव नहीं करना था. दूसरे पोर्शन में क्या है कि कोर्ट अलाउ ही नहीं करेगा कि आपको प्रूव करना है, प्रोहिबिट करेगा, रोकेगा, नहीं आप ये चीज नहीं प्रूव कर सकते हो. एंड दैट इज डॉक्ट्रिन ऑफ स्टॉपल. स्टॉप मतलब रोकना, रोकने का सिद्धांत, डॉक्ट्रिन ऑफ स्टॉपल, सेक्शन 115 टू 117. एक सिंपल सा एग्जांपल देता हूं. ए, आप में से कोई मार से था बड़ा इंटेलिजेंट, he transfer the property that he will inherit after his father will die. बाप के मरने के बाद में वो प्रॉपर्टी जो आनी उसने किसी को ट्रांसफर कर दी, पैसे ले लिए. आफ्टर दैट द फादर हैज डाइड. अब वो भाई साहब कह रहे नहीं जब मैंने ट्रांसफर की तब तो पापा एक्सपायर नहीं हुए थे. court will prohibit it because the doctrine of estoppel will apply. So there are various situations that we will find from section 115 to 117 where doctrine of estoppel is applied. Or in the simple words, you can say is that there are certain facts which the parties are prohibited from proving. Okay? Court nahi kahegi. Court will not allow that proving that my father was not died and at that time I was not the owner of the property. Okay? The third is the privileged communication. This is very important. Privileged communication. The privileged communication section 122 to 129. कुछ कुछ गवर्नमेंट की कम्युनिकेशन होती है, कुछ लॉयर और क्लाइंट के बीच की कम्युनिकेशन होती है. So there are various principles, various provisions, and the communication between those persons are prohibited by the various provision is known as privileged communication. Okay, so this is your homework. सेक्शन 122 to 129 घर पे बैठ के देखना कि अच्छा अच्छा कौन कौन सी है जो कोर्ट में आप प्रूव नहीं कर सकते, प्रिविलेज्ड हैं वो. ओके, दिस इज द फर्स्ट पार्ट ए. पार्ट बी. पार्ट बी इज रिलेटेड टू एविडेंसेस. एविडेंसेस जनरली मैंने बताया ओरल और डॉक्यूमेंट्री. इलेक्ट्रॉनिक एविडेंस भी फिर डॉक्यूमेंट्री में आ जाते हैं. ओके, या तो आप किसी को बताओगे हाँ जज साहब मेरे सामने मर्डर हुआ, मेरे सामने कॉन्ट्रैक्ट हुआ, और you will produce a document. There is only two way to give the evidence. So oral and documentary evidence. What is oral evidence? What is documentary evidence? In documentary, what is primary evidence? What is secondary evidence? Suppose there is a contract executed between A and B. एक contract उन्होंने किया. What is contract? Section 2H of Indian Contract Act. An agreement enforceable by law. So एक agreement था जो enforceable by law है, कोई subsequent उसमें impossibility भी नहीं आई. अब ये जो ओरिजिनल है इसको प्राइमरी एविडेंस कहेंगे, इसकी जो फोटोकॉपी है उसको सेकेंडरी एविडेंस कहेंगे, बट दोनों होंगे डॉक्यूमेंट्री एविडेंस. सो ओरल एविडेंस एंड डॉक्यूमेंट्री एविडेंस सेक्शन 59 टू सेक्शन 78. डॉक्यूमेंट्री में प्राइमरी सेकेंडरी, प्राइमरी कब देंगे, सेकेंडरी कब देंगे, प्राइमरी देना है, प्राइमरी नहीं हो तो सेकेंडरी कब देना है. Section 55B that related to electronic evidences. Okay. The second thing is the exclusion of oral by documentary evidence. And this is cardinal principle. Suppose for proving a things there is a document. A और B के बीच में एक एग्रीमेंट हुआ और उस एग्रीमेंट से में क्या है उससे रिलेटेड डिस्प्यूट है. तो आप में से सब लोग कहेंगे अरे भाई वो डॉक्यूमेंट ला के दिखाओ, उसको पढ़ के देखते हैं किसकी गलती है. सो व्हेन देयर इज एविडेंस ऑफ द कंटेंट ऑफ द डॉक्यूमेंट देन ओरल एविडेंस इज एक्सक्लूडेड. फॉर द कंटेंट ऑफ द डॉक्यूमेंट, एग्रीमेंट हुआ था इसके लिए आप दे सकते हो कि हमारे सामने एग्रीमेंट हुआ था, लेकिन एग्रीमेंट में क्या क्या था, कौन कौन सी कंडीशन थी, फॉर दैट डॉक्यूमेंट इज इंपॉर्टेंट. फॉर दैट ओरल एविडेंस इज नॉट अलाउड. दैट इज गुड आल्सो. ओके, सो MC वर्गीस, स्टेट ऑफ यूपी वर्सेस राजनारायण, राम नारायण बाजा बजाए. सो राजनारायण इज दैट पर्सन हु बाजा बजा दिया उन्होंने इंदिरा गांधी जी का. सो इज वेरी फेमस पर्सन राजनारायण. He contested against Srimati Sonia Gandhi, Indira Gandhi. State of UP versus Raj Narayan. So these 4-5 cases we will discuss under this chapter 3. Now come to the fourth chapter, and it's very interesting. In many movies, in many serial, you have listened this thing that when the offense is committed, and it is committed by 2-3 person, a group, and the police is not able to find out the relevant or the sufficient evidence to win the case. तो उसमें से एक आदमी को तोड़ते कि भाई आप इसके खिलाफ गवाही दो, आपको सरकारी गवाह बना देंगे और आपकी सजा खत्म हो जाएगी। सुनते हो ना? सो दैट इज नोन एज अकॉम्प्लिस, ये याद रख लो, ACCOMPLIC, accomplice. So in an offense there are more than two or more than two person, and one of them want to give the evidence against rest. So as when he is accused, he cannot give evidence against himself, because then what is the trial? But when he is removed from the charge sheet, his name is removed from the charge sheet, he can definitely give, he is the valid witness. And so the accomplice evidence is the chapter 4. Who is accomplice? Whether the accomplice evidence is reliable or not, and how much weightage that has to be given to the value of the accomplice. Because there is one interesting thing. Sometimes the student also asks, sir, किसी चीज को प्रूव करने के लिए कितने एविडेंस होने चाहिए? Section 31 is the answer of this. Section 31 of Indian Evidence Act says that as such there is no minimum number of the evidences, oral or documentary, that required. When it is proved, sufficiently established, then it is done. So maybe there are no other evidence except the accomplice, the person who participated in commission of the crime. Only he is the sole evidence. His testimony is the sole evidence. But the question is that he is the accomplice. Maybe वो ज्यादा एक्साइटेड हो गया कि सारी सजा माफ हो जाए, वो सारी चीज गलत भी बता रहा हो, and that's why there is the reasonable doubt, there is a question that maybe in the wake of pardoning his sentence, pardoning his crime, he is giving false evidence. But that is the necessity also, because there is no other evidence. And so there are two slightly, as such there is no conflict, but it seems to be the conflictory provision, section 133 and section 114B. Section 133 133 के कॉम्प्लेक्स का एविडेंस सही है, सेक्शन 114B की उसको थोड़ा सा प्रिसाइजली देखना है. So that we will discuss. 3 cases are there: Harun Haji Abdullah versus State of Maharashtra, Babuni Sahu versus King, and Ravinder Singh versus State of Haryana. These things we will discuss. Okay. So another important thing you have learned, that is accomplice, Sarkari Gawah. Okay. The 5th chapter, from 3rd and 4th, anything that you want to ask, or any explanation that you required, or anything that you want to say, you want to convey, you are welcome. Yes, बेटा कुछ बोलो, ऐसी क्या बात हो रही है?
Sir, in accomplice, what is done first? His name is removed from the charge sheet, or his testimony is recorded?
No, first, without removing his name, he cannot be the valid witness, no? Because when he is the accused, how he can give the evidence against himself? That is not allowed.
What if he denies giving testimony afterwards?
No issue. उसका नाम होता है.
Can police re-enter his name?
Maybe, but it's rarely happened. It's rarely happened because that is conditional. But he may become hostile. अगर suppose करो उस समय कहा कि okay, I will give, but that before going the case to the court, first police will record his statement. So that statement is there. And after that, before the court, suppose he became hostile, that he is not giving the, witness. So maybe later on there are the provision on the, the IPC for giving the false evidence and other things. Under that, charge sheet can be filed. but on that particular things, reinsertion of the that is not possible in that original case. Okay, जो ओरिजिनल केस है उसमें तो उसका नाम दोबारा से आएगा नहीं, लेकिन उसमें फॉल्स एविडेंस और बाकी सारी चीजें हैं, वो चार्ज दोबारा पुलिस लगा सकती है। ठीक है, ओके, हेलो, ओके,
Yes.
या, वेरी गुड क्वेश्चन। देखो कितना अच्छा इन्होंने पूछा, यही होता है। देखो चीजें तो आपके पास बुक्स हैं, यू कैन सफिशिएंटली अंडरस्टैंड एंड स्टडी, बट हाउ एक्चुअली, बिकॉज इट इज प्रोसीजरल लॉ, हाउ एक्चुअली इट वर्क्स, फर्स्ट उसे जब ट्रायल के दौरान, ट्रायल से पहले जब इन्वेस्टिगेशन हो रहा है, देन द पुलिस कम अक्रॉस दिस प्रॉब्लम दैट दे डिड नॉट हैव द सफिशिएंट एविडेंस, तो उन्होंने एक पर्सन को अकम्प्लिस बना लिया। अकम्प्लिस के लिए पहले उसका चार्जशीट से नाम हटाएंगे, नाम हटाने के बाद में उसका विटनेस में उसका नाम लिख दिया। सपोज ही आस्क कि उसके बाद में हॉस्टाइल हो जाता है, यानी वो एविडेंस नहीं देता है, उसको हॉस्टाइल बोलते हैं, या उसने कहा कि देखो वो ऐसा तो है नहीं कि गवाही नहीं देगा, बिकॉज दैट कैन बी कंपेल्ड in the CRPC. There is a provision and the pro forma is also there in the attached to the Indian Evidence Act. आप ये नहीं कह सकते कि मैं गवाही नहीं दूंगा, that can be compelled, court has that power, otherwise कोर्ट की प्रोसीडिंग में कौन आएगा। बट सपोज वो कहता है नहीं नहीं जी हमने ऐसा कुछ नहीं किया, सपोज वो उसको कहते हैं हॉस्टाइल, जाके वो झूठी गवाही देती। So in that situation, as such in the original charge sheet, it is not possible at that moment. Okay, but some other under some other provision giving the false evidence and all these things, another charge sheet can be filed under the different offenses. Okay,
Sir, what if there are 4 accused and 3 of them are ready to be accomplice? तो फिर पुलिस को उस तीनों को
no
छोड़ना पड़ेगा?
no 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 देखो, अंडरस्टैंड इट सृष्टि, अंडरस्टैंड इट। पुलिस का काम क्या है? क्रिमिनल को सजा देना। अकम्प्लिस तो इसलिए बना रही ना, उसके पास मजबूरी है, क्योंकि कोई गवाह नहीं है, समझ रहे हो? तो वो केवल एक लेते हैं, किसी रेयर में 2 भी लेते हो, बट जनरली एक लेते हैं, बिकॉज मेन पर्पस तो है कि सारे क्रिमिनल को सजा देना। बट द नेसेसिटी सच दैट इफ वन हैज नॉट बीन पार्डन देन ऑल विल गो फ्री, समझ रहे हो ना? इसलिए वो एक करते हैं। ऐसा नहीं कि वो चारों कह रहे हैं, चारों भी कह दे हम, ऐसा नहीं है, सजा सारों को दिलानी है। लेकिन अच्छा, इसमें भी वो देखते हैं जिसका रोल सबसे कम होता है, सबसे कम जिसका रोल होता है उसको करते हैं। तो दैट्स द थिंग। ओके,
Okay, sir.
या द 5th चैप्टर इज अबाउट विटनेस, कॉम्पिटेंस एंड एग्जामिनेशन। अब विटनेस क्या होता है? अब हमने अभी कहा कि एविडेंस 2 तरह के होते हैं। कोई बात हुई, या तो कोई बोल के बताएगा, या कोई डॉक्यूमेंट लिखा हुआ होगा। ए बी का बेटा है कि नहीं, बी ने अपनी डायरी में लिखा हुआ है, या उस समय जब हुआ था डॉक्टर की रिपोर्ट है कि बी का बेटा, दैट इज डॉक्यूमेंट्री एविडेंस। या बी आके कहे कि हाँ जी मैंने इनकी डिलीवरी करवाई थी और ये इस औरत से हमने इस बच्चे को पैदा करवाया, दैट इज ओरल एविडेंस। So there are only 2 things, oral and documentary evidence. Electronic evidence is sub part of the documentary evidence. Okay. Now, what is witness? A person who give the oral evidence is witness. एक ऐसा आदमी जो आके orally कुछ बताता है उसको witness कहते हैं, और उसकी गवाही को testimony कहते हैं। Some of you are very maybe from very good background, वो तुरंत कैच कर लेते हैं। कुछ लोग ऐसे भी होते हैं जो बेचारे थोड़ा रूरल बैकग्राउंड से, उनके लिए बड़ी महाभारत होती है विटनेस टेस्टिमोनी, कई दिन तक अलग सा माहौल रहता है कि टेस्टिमोनी क्या है। सो विटनेस इज दैट पर्सन हु गिव द ओरल एविडेंस बिफोर द कोर्ट। नाउ द क्वेश्चन इज हु कैन बी विटनेस। आपसे पूछे बताओ विटनेस कौन होता है, तो आप कहोगे कि एनी पर्सन हु गिव द ओरल एविडेंस। विटनेस कौन हो सकता है, यानी कौन गवाही दे सकता है? यस अरशद, गवाही कौन दे सकता है? हु कैन बी विटनेस?
Sir, any person who has witnessed the commission of offense.
Who has seen the?
Witnessed the commission of offense.
ना ना ना, तुम तो गलत समझ रहे हो। विटनेस वो होता है जो गवाही देता है, जैसे आपके सामने कोई ऑफेंस हुआ हो या आपने वो ऑफेंस देखा हो या सुना हो।
That is what I'm saying, sir. जिसने ऑफेंस देखा हो, विटनेस किया हो ऑफेंस।
हाँ, बट क्वेश्चन ये है कि कौन हो सकता है, आदमी हो सकता है, औरत हो सकती है, छोटा बच्चा, बड़ा
Anybody.
बच्चा, एनीबॉडी। बट अब यहाँ पे 3 क्वेश्चन है। एक क्वेश्चन ये है कि भाई हमने कहा विटनेस इज दैट पर्सन हु गिव द ओरल एविडेंस। अब हम लोग वी आर वेरी लकी दैट वी कैन स्पीक। देयर आर सम पर्सन हु कैन नॉट स्पीक, डम्ब, गूंगा। अब डम्ब विटनेस कैसे ओरल एविडेंस देगा? वो बोलना चाह रहा है, बोला जाता नहीं उससे। सो द डम्ब विटनेस, so this chapter 5th, the witness competence and examination, witness competence and examination is divided into 2 parts. The first part is related to witness and the second part related to examination. 3 category of witness, most important category we will discuss here. The first one is the one you can say child witness, that we will discuss later on. First is the second is the dumb witness. So any person who cannot speak, through the sign he can convey or through the writing he can convey. तो उसने क्या क्या देखा वो लिख के कोर्ट को देता है. नाउ द क्वेश्चन इज वेदर इट इज नॉन एज ओरल एविडेंस और डॉक्यूमेंट्री एविडेंस. बिकॉज हमने क्या क्या विटनेस क्या है जो ओरल एविडेंस देता है, ओरली तो वो कह ही नहीं पा रहा. एंड सो दिस थिंग इज नोन एज ओरल एविडेंस because he is unable to speak, but whatever he want to convey is, if he was not the dumb, then he can convey through through speaking. So ऐसा जो dumb witness जो बोलता है साइन के थ्रू या राइटिंग के थ्रू, उसको भी हम जो है विटनेस की कैटेगरी में रखते हैं, ओरल एविडेंस की कैटेगरी में रखते हैं, ना कि डॉक्यूमेंट्री के. द सेकंड इज चाइल्ड विटनेस. बच्चा है, छोटा है. अब ऐसे तो like the author say that anybody can witness. एक मूवी है ना Ratatouille, anybody can cook. You can watch that movie, very interesting, Ratatouille. So anybody can witness, but the person who is of the tender age, छोटा बच्चा है, पूरी तरह से समझ. विटनेस के लिए 2 इंपॉर्टेंट है कि वो क्वेश्चन को समझ रहा हो और एक रीजनेबल आंसर दे रहा हो. दैट इज रिक्वायरमेंट. बट चाइल्ड है, उसकी टेंडर एज या बहुत ज्यादा बुजुर्ग है, कम सुन रहा है, तो उसमें क्या होता है कि चाइल्ड में अगर वो बातों को समझ रहा है और उसको अच्छे से दे रहा है तो ही कैन आल्सो बी विटनेस. सो सेक्शन 118 चाइल्ड विटनेस, सेक्शन 119 डम विटनेस, ये प्रोविजन भी आपको देखनी. एंड देन देयर इज द होस्टाइल विटनेस 154. आपको किसी ने पीटा, आपका दोस्त वहां खड़ा था, आपने अपने दोस्त का नाम लिखवा दिया FIR में भी कि भाई मेरा दोस्त खड़ा था, उसने मुझे बचाया. गवाही देने के टाइम पे आया तो दोस्त मुकर गया, ना जी ना, मैंने तो कुछ नहीं देखा, या कह दे नहीं ये इसी ने उसको मारा था उल्टा. तो दोनों पॉसिबिलिटी हो सकती है, या कह दे इसने उसको मारा था, या मैंने नहीं देखा, या मैं नहीं था. तो दैट इज नोन एज होस्टाइल विटनेस. विटनेस वहां जाके होस्टाइल होगा. सेक्शन 154. So 3 things we will discuss under the first portion of chapter 5: child witness, dumb witness, and hostile witness. Child witness section 118, dumb witness section 119, and hostile witness section 154. Now the second portion of the chapter 5 is about examination. जब आप एक गवाह को लेके जाते हो, विटनेस को लेके जाते हो, so these things you will observe when you will go to the court as a judge or maybe as a lawyer. So the first, suppose I call the witness. Okay, क्रिमिनोलॉजी देखो, क्रिमिनल ट्रायल में हर में 2 साइड होती हैं, क्रिमिनल हो, सिविल हो, अपील हो, कुछ भी हो, कंप्लेंट हो, because that it is adversarial system. So in the criminal side there is 2 sides. One is the prosecution side, another is the accused side. In the civil matter, the plaintiff side, the defendant side. In the appeal, the appellant, the respondent. So in the criminal trial, the prosecution side or the accused side. Suppose the prosecution side में witness का नाम है A. तो जो प्रोसिक्यूशन उसको बुलाया तो पहले प्रोसिक्यूशन उसको एग्जामिन करेगा. मूवीज में देखा होगा आपने और किसी सीरीज में देखा होगा कि बताओ क्या क्या हुआ उस रात। मैं सर उस रात उठा तो देखा कि वो रो रही थी, उसके कमरे में जाके देखा उसके चाकू लगा हुआ था। तो आपने क्राइम होते हुए नहीं देखा? नहीं, मैंने क्राइम होते नहीं देखा। यानी उसने ये देखा केवल ये रो रही थी, वो उसका नाम बोल रही थी। किसी ट्रायल में ये हुआ कि मैंने देखा कि वो भाग रहा था और उसको स्टैब किया। किसी ट्रायल में कुछ और होगा। So the person who called the witness first, he examined that witness. It is known as examination. Section 137 to 139 and 155, these provision we will discuss. Then the second is, अब इन्होंने एग्जामिन कर लिया। अब सेकंड पार्टी जिसने कॉल नहीं किया विटनेस को उसने नहीं बुलाया, दूसरे ने बुलाया, वो उसको क्रॉस एग्जामिन करेगा। ऐसे ही जब अक्यूज साइड का कोई गवाह बुलाता है तो अक्यूज साइड पहले उसे एग्जामिन करेगा, फिर प्रोसिक्यूशन उसको क्रॉस एग्जामिन करेगा। क्रॉस एग्जामिनेशन टू फाइंड आउट द ट्रूथ। कहेगा अच्छा भाई साहब आप सपोज इन द ट्रायल, अच्छा आपने मर्डर होते हुए देखा, तो किससे मर्डर हुआ? सर उसने चक्कू ले रखा था। वो कहे झूठ बोल रहा है, फोरेंसिक रिपोर्ट में आई है कि गोली से मौत हुई है, पकड़ा जाएगा वो, उसकी गवाही कोई काम नहीं आई। सो द क्रॉस एग्जामिनेशन, and after the cross examination if anything is left, then the first party who called the witness can re-examine it. So there are three things. Examination, इसको बोलते हैं एग्जामिनेशन इन चीफ, कोर्ट में कई बार चीफ भी बोलते हैं। क्रॉस एग्जामिनेशन और क्रॉस बोलते हैं। एग्जामिनेशन इन चीफ, क्रॉस एग्जामिनेशन एंड री एग्जामिनेशन। अब जब ये दोनों मूवी आप देखो या और कोई मूवी देखो, हॉटस्टार पे यू कैन फाइंड दीज मूवीज, क्रिमिनल जस्टिस सिस्टम 1 एंड क्रिमिनल जस्टिस सिस्टम 2। आप बाकी चीजों इमोशन में मत जाना है, आपको केवल देखना है कि ट्रायल, हाउ दिस ट्रायल इज प्रोसीडिंग, हाउ द एविडेंस आर कलेक्टेड, हाउ होल द री इनेक्टमेंट ऑफ द पास्ट इवेंट इज डन, and how the witness give their testimony, how that has to be examined, cross examined and re-examined. All these things you have to see. And under chapter 5 there is only one case that we have to discuss, State of Bihar versus Lalu Prasad. So that is chapter 5. Anything that you want to ask from chapter 5? Yes guys, please.
सर आपने मूवी नेम बताया था, क्या रिपीट कर सकते हो? कौन सी मूवी नेम?
क्रिमिनल जस्टिस सिस्टम, क्रिमिनल जस्टिस सिस्टम 1 एंड क्रिमिनल जस्टिस सिस्टम 2।
इससे पहले भी बताया था सर शायद आपने।
यही बताए, हॉट स्टार करके जो चैनल है हॉट स्टार डिज्नी वाला, दैट इज अवेलेबल देयर। बाकी आप अपने किसी दोस्त से अरेंज करते हो या कहीं से भी करते हो, दैट्स योर हेडेक। बट दोनों मूवीज में, फर्स्ट मूवी में मर्डर होता है and the story is very interesting. There is one taxi driver who dropped one passenger. She was young lady. Then there was one night stand, and then when he woke up there is the murder of this lady, and the police arrested this person because the police reenacting the fact. This first chapter, ye reenactment etc., you will not find in the book, you will not find in the case material. सो उसमें वो रीएनेक्टमेंट कहते हैं, भाई टैक्सी ड्राइवर होगी, इसने कुछ कहा होगा, उसने मना कर दिया होगा, वो अपना पूरा एक सर्कमस्टांसेस, वो एक चेन ऑफ स्टोरी बताते हैं, उसको बोलते हैं ना प्रोसिक्यूशन की स्टोरी, डिफेंस की स्टोरी, एंड फिर उसमें किस तरह से चीजें आती हैं। सो दैट थिंग यू कैन वॉच। ओके, कैन वी मूव फर्दर?
Yes, sir.
The next and the last chapter is chapter 6, presumption. बहुत बार प्रज्यूम किया है, 7th 8th 9 जो हिंदी मीडियम वाले, उन्होंने माना मूलधन 100 रुपए, माना मूलधन 100 रुपए, सारा मैथ निकाल दिया, या फिर आप वैसे भी मानते होंगे। सो देयर आर सर्टेन प्रजम्पशन, प्रजम्पशन भी ऐसे इंटरेस्टिंग, मतलब दिमाग हिल जाए, मजा आ जाए। सेक्शन 112 बड़ा इंटरेस्टिंग प्रजम्पशन है। सपोज story I want to tell you, or you can say some facts I want to tell you. Suppose there is person A, and he married to a lady B. This lady B has a paramour. इसका पहले से ही कोई प्रेमी है. And after the marriage, A went to foreign country, America. When he returned, he find that there was the third member in his family because his wife delivered a baby. And he know that this baby is not his baby. वाइफ को पता है इसका बच्चा नहीं. शादी के 280 डेज के मतलब शादी ड्यूरिंग मैरिज ये पैदा हो गए. Now who is the father of this baby? A है या उस लेडी का पैरामोर जो उसका प्रेमी था वो है? Yes, please give me the answer.
He will be presumed to be the father of the child.
Yes, please repeat. I could not hear.
Sir, he will be presumed to be the father of the child.
Your voice is not clear. So section 112 basically talk about this presumption. If you talk about biological parent, biological father, definitely the paramour of the wife was the biological father. But the law will not allow this person to prove this thing. And law will presume, yes, A will be presumed. Yes, very good, Udichi, very good. Law will presume that A is the father of B. थोड़ा सा odd सा लगता है ना? But this is not the something that is true. Presumption वही होता है ना जो presume करते हैं. So this is presumption. So under the presumption, two period we will give to this chapter. Section 4. May presume, shall presume, and conclusive proof. Three type of presumption. May presume, shall presume, and conclusive fact. Section 105. Section 111A. 111A. Section 112. The problem that I told you is from section 112. पढ़ना उसको 2-3 बार. Section 113. Section 113B. Section 113A. Section 114. Section 114A. All these related to the presumption. Some are related to conclusive proof, shall presumption, or may presumption. Like in the trial of the rape, two things has to be proved by the prosecutrix or prosecution side. One is the sexual intercourse, another is that she was not consented, or it was against her will, or the other thing. Now, as the traditional rule, the prosecution side has to prove that she was not consented. But there is the presumption in the Indian Evidence Act that when the prosecutor says that she was not consented, the court will presume that she was not consented. उसने कहा कि नहीं मेरी कंसेंट नहीं थी तो कोर्ट मानेगा कि उसकी कंसेंट नहीं थी, आपको नहीं प्रूव करना. Now the burden is on the other side to prove that she was consented for the sexual intercourse. So basically the presumption shift the burden. There are two concepts that you can write also. One is section 101 and another is under section 103. Burden of proof and onus of proof. The burden of proof is only on the person who goes to the court. चाहे सिविल केस हो चाहे क्रिमिनल केस हो, जो कोर्ट के पास जाता है कि जी जज साहब मेरे खिलाफ ये अन्याय हुआ है, that something wrong has happened to me, he has the burden to prove all the ingredients before the court. Now you will find that your criminal law teacher, उसने जो बड़े ब्यूटीफुली जो बताया ना इंग्रेडिएंट अलग 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 अलग, वो अब काम में आएंगे आपको, वो सारे आपको प्रूव करने हैं अलग अलग फैक्ट देख के. And the second thing is that the onus of the proof, that is different. The onus of proof keep on shifting through the burden it shift. Like normally, the burden is on the prosecution. The prosecutors to prove that she was not consented. But through the presumption, it shifted on the accused side. So the may presume, court presume भी कर सकती है, हाँ हुआ होगा, और court presume नहीं भी कर सकती. Shall presume, the court will presume, but can allow the other party to adduce the evidence against it. And the conclusive proof, when the fact A is proved, the court even will not allow the party to adduce the evidence. When the fact A is proved, the fact B is also presumed to be proved conclusively and will not allow. Like in section 112. When the child is born during the subsistence of the marriage, it is presumed, the conclusive proof is that it is the child of the person who is the husband in this marriage. And court will not even allow to do any type of medical test, DNA test. Okay. But if the question is about the paternity, and the paternity is not as covered under section 112, then the DNA test can be allowed. Okay. So suppose there is a woman A, उसका बच्चा B है, और कोई माँ से एनडी तिवारी जैसा C है. Now this is not the question or the problem related or covered under section 112. Now this person can sue that to prove the paternity, the DNA test can be allowed. But to disprove whatever provided under section 112, the DNA test is not allowed because it is something that rebut the presumption. So rebuttal is not possible. So presumption, rebuttal, these things. And the presumption is of three types: may presume, shall prove, and conclusive proof, and other things. Gautam Kundu and state versus state of West Bengal, and Dipan Vita Roy versus Ronoborto Roy. These two cases we will discuss under this chapter. So this is all about your syllabus. The books I already have told you that 2 books are prescribed in this case material, and we have not to go beyond these things. We have to stick ourselves to the syllabus that has been provided. To understand all other things we can discuss, but we have to stick ourselves, because at the end of the semester, the question paper or the you can say the question will be from the syllabus that has been prescribed. So why to waste the time? But to understand the the provisions or the help of some other law we can take. Okay, 3 things you have to manage. One is the case material, another is the Bail Act, and third one is one book. And one genuine advice I want to give, वैसे तो बिना पैसे के एडवाइस को लेता नहीं, लेकिन फिर भी दे रहा हूँ. See this book from Vipa P. Sarthi or Justice M. Munir. Any of these book you can purchase. ज़्यादा रुपए की नहीं आती हैं, फिक्स साइज होते हैं. आप बाकी अननेसेसरी मटेरियल और अननेसेसरी चीज़ें खरीदोगे, उससे ज़्यादा बेटर है. इट विल बी इन योर लाइब्रेरी, पर्सनल लाइब्रेरी. लीगल प्रोफेशन में अब आपको ग्रो करना है, बढ़ना है, तो ये रहेंगे आपकी लाइब्रेरी में. एंड दैट विल गिव द बेटर अंडरस्टैंडिंग टू understand the problem. At the time of examination also, this will be helpful. During your LLB course, whenever there is the issue related to evidence law or some other things, that would also be helpful. After the LLB, when you go for the preparation of the judicial exam or some other competition exam like the APO, ADA, etc., that would also be helpful. Even when you go in the practice, that would also be helpful. And even you sit idle एट द वर्स्ट ऑफ द थिंग फिर भी वो आपके अच्छा लगेंगे, अच्छा भाई साहब आपने LLB की है. So this is my advice that please purchase one book also. So these three things you required, and along that our discussion, through the discussion we will understand section by section the reasoning, the scope of the provision, and the cases that based on the provision. All these things we will discuss. So with this, today class is over. And if anything you want to ask, you want to share with me, you are welcome. After that I will leave this meeting. Yes, anything that you want to share or anything that you want to ask?